All right, hi, I'm Dan Estrada. This is Engineering Ethics at NJIT. It's February 11th. We're on lesson 5. Let's go ahead and jump into the course. All right, we're on lesson 5. This week we're going to be talking about duties and obligations, and we're going to be thinking about whistleblowing. Remember that we're lesson 5. Remember lesson 4, we talked about Dennis Joya's discussion of his decisions as field recall coordinator in Ford during the Pinto controversy. Remember, this is lesson 4. From lesson 3, we introduced the Pinto and talked about consequentialist reasoning. Consequentialism was the first of our ethical theories. Then we looked at Dennis Joya and the decisions he made within Ford during the Pinto case. And part of the point here was not to call Dennis Joya a bad guy, but to recognize the difficulty of his decision in the corporate environment that puts pressure on him to conform to the standards, to conform to the script that he was following within that organization. Right. So even if Dennis Joya was a good guy, right, the question is how difficult, or the issue is how difficult it is to make these decisions. A lot of people in their essays wrote about how Joya shouldn't be held responsible. He didn't make the wrong decision. He was understandably following the rules of his job, right? And you have to do your job. So we talked about, introduced a little bit about that tension in lesson 4. We talked about sort of the psychological disposition to follow orders, to obey commands, especially when they're issued by an authority figure. We mentioned briefly, and some people wrote about this, the Eichmann trials in Jerusalem, and in particular the Nuremberg defense. I plan to talk about this more during the hangout on Tuesday. The Nuremberg defense is just following an order. It's a defense given often by people who are found to do something unethical or immoral or illegal, but when they've been told to do so. If you remember from the Milgram experiments, the guy says, well, you'll take responsibility for these things, and the teacher says yes, or the experimenter says yes, I'll take responsibility, and so he goes through with it. Right? The idea is that if someone else is responsible, if someone else is giving the orders, if someone else is in charge, then maybe the person carrying out the orders isn't so responsible. A lot of people argued this way in the forums. A lot of people argued that Joya wasn't responsible because he was just following orders. We'll talk about Eichmann, the Nuremberg defense, superior orders, a little bit more during the hangout on Tuesday. The lesson for this week is mostly about whistleblowing, which is when you don't follow orders. Whistleblowing is the case where you reveal some fact outside of the normal procedures for discussing grievances within an organization. I actually have a better definition on the slides in the Prezi. Right, so a whistleblower is someone who exposes illegal, unethical, or dangerous activity or otherwise inappropriate behavior within an organization, and they take channels outside of the approved organizational channels. Right, so usually an organization will have a procedure for issuing grievances. You have a boss. Maybe the boss has an open door policy where you can talk to them, or maybe there's a form that you fill out to issue grievances. These are all the standard procedures within the organization. A whistleblower is someone who goes outside those standard channels. In other words, someone who doesn't follow the rules that they're being given. So we're going to talk about whistleblowing today. We're going to give you some examples of whistleblowers, so people who disobeyed the rules governing their job, right? Who went outside their job. So this is supposed to be in contrast with Dennis Joya from last week. Dennis Joya followed his job, or he followed his script. Right, so this week we'll talk about people who go off script. Our discussion of whistleblowing is going to be under the framework of deontology or duty theory. This is the second of our ethical theories that we'll talk about. And at the end of the lesson, I'll talk a little bit more about the theory abstractly. But the thing that you should know, just to get going, is that deontology, it means duty theory, and deontologists think that you might have duties that are more important than the consequences, that thinking about your obligations, your duties, contracts you sign, your obligations to do your job, right, that these are more important, that these outweigh any consideration of the consequences. Remember, the consequentialists think that you only have to consider the consequences, weigh the outcomes. If more people die, in one choice versus the other, then the one that more people die is the bad choice, right? The one with less people die is the good choice. This is the trolley problem sort of reasoning. Deontologists don't always disagree with the consequentialists about particular cases. In fact, on particular cases, the deontologists and the consequentialists might agree on the outcome about what you should do. But the difference here is about the way that they reason about the cases. Deontologists think that it's not the consequences that matter so much. What matters is the obligations, your responsibilities. The deontologists think that responsibilities are more important than the consequences, and that sometimes you ought to carry through with your responsibilities even if they have negative consequences. So we've run into cases like this before, and people have argued this way in the forums when we talk about gun rights or when we talk about tobacco. Right? A lot of people say, well, look, yeah, a lot of people die from tobacco, but we know that tobacco kills people, and people make the choice anyway. And it's more important to let people make their free choice to smoke tobacco or to have guns. It's more important to keep their rights to choose those things, even though they have these negative consequences, even though lots of people die. Right? We could stop lots of people from dying of tobacco-related cancers. We could stop a lot of people from dying from lung cancer if we just ban cigarettes outright. Right? That would save a lot of lives. But some people argue that it's less important that we save the lives, it's more important that we give people the free choice. And sometimes giving the people the free choice results in people dying. But that's a consequence, but it's not the moral decider, right? The moral thing for the deontologists is the principles, the obligations and responsibilities that you're following through. And so you might think that we have, the Second Amendment protects gun rights. So even though guns kill a lot of people, the Second Amendment protects gun rights, and it's more important that we protect the Second Amendment than it is that we protect the lives of the people. It's more important that we protect the freedom to choose to smoke, the deontologist thinks, than it is to protect the people who, than it is to protect the lives of the people who die from smoking. I'll come back at the end of the lecture to talk a little bit more about the theory itself, about Kant. Immanuel Kant is the guy who comes up sort of champions the theory. The real core of the lecture is about whistleblowing itself, and I have these two articles, one from Richard DeGeorge, Ethical Responsibilities in Large Organizations, and the other from Douglas Birch, Whistleblowing Ethical Obligations in the Ford Pinto Case. Both of these articles concern the Pinto case, right? They go back over the Pinto case, the one that we've talked about for a couple of weeks now. And their question is, should the engineers in the Pinto case have done more to stop the Pinto from coming on the road? So we've looked at the field recall coordinator. We've looked at Dennis Joya, his decision. What DeGeorge and Birch argue is about the engineers at Ford who knew about these problems with the car, with the parts in the car, that there were these manufacturing problems that needed to be repaired. There were engineers at Ford who understood the problem, raised some challenges, but no one at Ford blew the whistle. In other words, no one stepped outside of the normal procedures. They might have let their concerns be known to their superiors, and they might have gone through the normal corporate procedures for making these concerns known. But they didn't step outside of these corporate procedures to make it a bigger case than Ford was dealing. Ford was willing to deal with the problem. So DeGeorge and Birch argue whether they have more of an obligation, whether the engineers at Ford had more of an obligation to blow the whistle. DeGeorge says no. DeGeorge is going to say that the standard for whistleblowing should be relatively high, and that engineers have the obligation. DeGeorge's position is that the obligation for engineers is to follow through with the duties in their job. DeGeorge says, look, if there's a serious threat to public safety, then the engineers have an obligation to see that that threat to public safety is dealt with. Right? There's the code of ethics and so on that say that engineers have a responsibility to make sure that things that are unethical are not happening. DeGeorge fully admits that. But DeGeorge says engineers don't have the responsibility to be ethical heroes. They don't need to go above and beyond what their job demands of them. The job of an engineer does demand consideration of ethics. It does demand following the ethical code. But that doesn't demand sacrificing your job or potentially right, your career for the sake of an ethical principle, especially if you don't know that committing to that ethical principle will do any good, right? If it's not going to stop the ethical harm from happening, then DeGeorge says that you shouldn't be required to put your job on the line. To do that, it might be a good thing, but DeGeorge says that we're not requiring engineers to be heroes. They have to be moral, but they don't have to be like superheroes. They don't have to go above and beyond what any other person would do in their position. Douglas-Birch argues against DeGeorge and says, no, the standards for whistleblowing ought to be fairly low, and that engineers should feel free to whistleblow when they feel that the ethical concerns aren't being taken seriously by their organization. So DeGeorge says that the standards should be fairly high and that whistleblowing should be rare. And Douglas-Birch says that the standards should be fairly low and that whistleblowing should be more common than it is. It should be more protected than it is. So the core of this lesson is going to be the debate between these two thinkers. DeGeorge, in his article, gives five principles on which to determine whether whistleblowing is ethical. And then Birch sort of goes through these principles and say why they're too strong. Let me jump into the lesson plan. I'm sorry, the Prezi one more time. Yeah, so a whistleblower is someone who exposes unethical behavior within an organization outside of the approved channels. The book goes over a couple of different ways of thinking about whistleblowers. So whistleblowers disclose information intentionally. If you accidentally leak information, or if you send an email and someone reads that email over your shoulder, you're not really whistleblowing in those cases. Maybe you're leaking that information, but you're not doing it intentionally, right? So whistleblowers intentionally leak information outside of the approved channels, and importantly, that the information that they leak is significant to an ethical problem. So it's not just that they're releasing trade secrets or that they're exposing some other kind of financial scandal or business plan, right? The point is not to release trade secrets. The point is to expose an ethical difficulty. So if this information is exposed intentionally because it poses a significant ethical problem for the organization, and importantly, that the person exposing the information should be an employee or at least a former employee of the organization or otherwise associated somehow with the organization. So the contrast case here is with someone like Mark Dowie, who was a journalist. Mark Dowie got access to that memo, the Pinto memo that exposes the calculation. But Mark Dowie wasn't a whistleblower because he wasn't an employee of the organization. He was a journalist coming across these documents from the outside. So he released information that has ethical significance, but he's not an agent of the organization that's keeping this information secret, and so he's not a whistleblower. One last bit that the book talks about is that the recipient of the information, right? So it's not just that you're giving this information to, say, a competitor or some other organization that isn't equipped to deal with the ethical problem, right? So it's important that the whistleblower is giving the information to someone in a position to act on the ethical challenge. Sometimes that's a regulatory agency, maybe a government agency that's designed to look after these ethical issues. Sometimes it's to an ethics board. Sometimes it's to a journalist to make the information public, right? Because maybe the regulators aren't helping, and maybe it's better to make the information public and create a big scandal. This is how Mark Dowie was operating, right? He released the Pinto memo to the public, right? Published it in the magazine, in Mother Jones, and that's public outcry, right? The media outcry is supposed to generate the change to the ethical situation. All right, so not everyone is a whistleblower. Whistleblowers have to meet these kinds of conditions. So we can talk about whistleblowers then. The book goes over some of these examples. I think some of these examples might appear on the quiz for lesson 5. The first example to talk about is Ernest Fitzgerald, C5A. Ernest Fitzgerald, here he is. He was a whistleblower in 1968. He worked for Lockheed. I think it might not have been Lockheed Martin at the time. Lockheed is a big aerospace engineering aerospace firm, right? They build all these planes. They're a big military contractor. And so they get a lot of money from the military in the building. So this is a cargo plane, the C-5A. And in the building of this plane, the plan to build the plane ended up experiencing huge cost overruns, $2 billion worth of cost overruns in 1968 dollars. This is a huge amount of money. Fitzgerald knew about these cost overruns, and he argued several times with his superiors in the organization, in Lockheed, to first of all, to make the cost overruns public. I mean, this is taxpayer dollars, right? This is money being given by the government. And if you know anything about military technology, you know that these kinds of cost overruns are very common. F-35 is the plane that does, yeah, that's getting all the blowback today. The F-35 costs $1.5 trillion. Something like $1 billion a plane, yeah. So $100 million a plane. And these planes, so this is the newest version of this, right? One of the reasons these planes ran so far over budget was that they all wanted these vertical takeoff and landing so they could land like helicopters instead of having to go off a runway. But having all that gear to do that was very expensive. It made the costs go way over budget. And the planes don't work very well either. A lot of the military pilots have problems flying the planes. They're not as maneuverable because of all this extra gear. So there's been a big scandal. This is scandal still going on. You can, if you want to talk about the F-35, if you're into military technology, that might be something to do. So this is one of these previous cases of military overruns, spending overruns. There's $2 billion for this cargo plane over budget. Fitzgerald knew about the overruns, argued with his superiors to try to get a handle on this situation. Eventually, the engineers are called in front of the Senate to explain the cost overruns. Fitzgerald is told not to talk about the overruns, not to explain anything that's happening, and sort of pass it off. But Fitzgerald doesn't do that. He doesn't listen to his superiors, and when he's called before Senate and has to testify under oath, he tells the truth, that this plane is $2 billion over budget, and it's costing the taxpayers a bunch of money. When Fitzgerald blows the whistle to the Senate under oath, even though he's told not to, he receives a lot of blowback, professional blowback. So he's stripped of his duties. He's reassigned to sort of bogus jobs. He's sort of sent all over the place to do all sorts of bogus jobs. He's eventually fired by Nixon himself. The quote here is, "Get rid of that son of a bitch." Right, so the blowback here is not just from his immediate superiors, but it goes all the way to the top of the government. Fitzgerald sues, and it takes several years, 4 years, and nearly $1 million worth of legal fees to get his position reinstated, and to recognize that he's not the bad guy in this situation, but in fact he's just the messenger giving bad news that the military doesn't want released to the public. Now, Fitzgerald had a lot of bad things happen to his career. He's also a sort of a bureaucrat, a paper pusher, right? He works an office job, but in this case, his office job required him to do something. He was told by his superiors to do something, and in this case, lie to the Senate when they were asking about these cost overruns. He refused to follow his orders, and instead he told the truth. He received a lot of blowback in his career as a result of this. But one of the good things that happens as a result of Fitzgerald's behavior is that he starts the process that ends up becoming the Whistleblower Protection Act of 1989. Starts off as the Civil Reform Act of 1978. These are the first legal protections for whistleblowers that exist. We might as well look at this. So the Whistleblower Protection Act is not very strong. First of all, it only protects federal whistleblowers who report on government misconduct. because Lockheed Martin was a government contractor in this case. Fitzgerald's case ends up being relevant to government employees. It's a government contract. Other government employees are also protected under the Whistleblower Protection Act. But this isn't a protection for whistleblowers generally, and if you work in private corporations that aren't related to these government contracts, then you might not be protected by the Whistleblower Protection Act. So the laws protecting whistleblowers in this country aren't very strong. They only protect federal whistleblowers, and they only protect them in some cases. So another thing you might want to do research on for this week's lesson for your essay is look up the protections for whistleblowers, maybe the protections for whistleblowers in your own field, and how that might matter to your ethical decisions in the future. I will point out in the Code of Ethics for Engineers, and in I believe 2 weeks, yeah, in lesson 7, we'll go over the NSP in more detail. But the NSP Code of Ethics, we've looked at it a little bit. We read through the preamble, we read through the fundamental canons. I just want to point out briefly, if we look at these rules of practice, so remember that the rest of the Code of Engineers basically goes over the fundamental canons. Code of Ethics for Engineers basically goes over the fundamental canons and elaborates on each canon. So the first canon, hold paramount the safety, health, and welfare of the public. Well, so the first rule of practice here, engineers shall hold paramount the safety, health, and welfare of the public. And then it explains and elaborates what that means. And I just wanted to call attention really quickly to 1C in the rules of practice, that engineers should not reveal facts, data, or information without prior consent of the client or employer, except as authorized or required by law or this code. Notice that it separates out the law and the code. And this is one thing that's really important to understand when thinking about whistleblowing, that the law is different from the ethics. The law isn't designed to make everyone follow the ethical rules, right? The law isn't designed to make you be ethical. The law is designed to offer some protections in some cases, but there's lots of ethical codes that aren't explicit in the law, and that sometimes following the ethical rules requires doing more than what the law requires. And the Code of Ethics makes this clear, right? So sometimes the law requires things. Sometimes the Code of Ethics requires things. Maybe the law doesn't require that you do things, but the Code of Ethics does. Maybe the law makes something illegal that the Code of Ethics requires that you reveal, right? So if you're working for a corporation that's doing something that represents a clear threat to public safety, but you're under some contract that has a non-disclosure agreement or some other kind of clause that makes you unable to speak about the job. Well, right, so on one hand you have this law, right, this contract that you've signed that says you're not allowed to disclose the information that you know, but on the other hand you have the ethical code that says that, look, if there's a threat to the health, safety, or welfare of the public, that you have an ethical obligation to make that known. The law says that you have to keep it secret. The ethics say that you have to make it known. And the Code of Ethics recognizes that sometimes the law and the code come apart, and it recognizes that you sometimes have an obligation to follow the code even if it goes against the law. Right? So this is what the whistleblowing is about. Whistleblowing is about breaking the law, breaking a contract, going against the established rules in order to secure the health, safety, and welfare of the public, and otherwise follow through with the ethical obligations for engineers. This is not something easy to do, right? Last week we talked about all the psychological pressures against doing this, and we see from a case like Ernest Fitzgerald in the CA5 that sometimes disobeying orders results in a lot of penalties, and you might not want to face these penalties. Right? Your job might be on the line, your career might be on the line, your capacity to feed and house your family might be on the line. Right? So making these decisions is very difficult. The point here is not for me to finger wag at you and to tell you to always disobey orders. The point is to make clear that you know that it's an option, right? That you don't always have to follow your orders, that sometimes you have to follow the rules of ethics, and that might demand more of you than what your boss tells you to do. So Ernest Fitzgerald in C5A is one of these cases. Another case that the book goes over that's a sort of famous case in engineering ethics is another airplane case. It's the Dan Applegate in DC-10. So these are both famous cases in the history of engineering ethics. The book talks about them in detail. I think the quiz talks about them. If these cases interest you, if you're interested in airplanes, this sort of engineering this side of engineering. Please investigate these cases further. Do some independent research. Write your essay on these cases. The DC-10 was a 1974 plane. This was made by Corvair, who was a contractor for McDonnell Douglas. McDonnell Douglas is another one of these large contractors. They contract for the government a lot, but they also build a lot of these planes. Dan Applegate was a senior engineer for Corvair, who was one of these McDonnell Douglas contractors. Dan Applegate was aware that there was a defect with the cargo doors, that the cargo doors weren't closing properly. Applegate was aware of this defect, and he had done a lot of efforts to redesign the cargo doors to avoid the defect. He called meetings within Corvair to make these design problems known, but Corvair decided to not let McDonnell Douglas know about the problems because letting McDonnell Douglas know would have incurred, I mean, if they'd actually had to repair the cargo door design, it would have caused cost and time delays, and this would have threatened the contract that they had in McDonnell Douglas. Corvair didn't want to threaten that contract, and so they sort of kept this cargo door defect quiet. Remember, Dan Applegate made the problem known within his own organization, but once that was shut down within his organization, Dan Applegate stopped there, and he didn't blow the whistle. He didn't go outside of the organization. He just kept his mouth shut after that. And then a few years later, in 1974, a plane crashes full of passengers. It was a passenger plane, crashes in Paris, kills 300 people, 346 people. And the defect was exactly this cargo door defect. And when the investigators were looking at what caused the accident, they pulled up all these old files from Dan Applegate where he made the problem explicit, where he tried to get something done about it, and then nothing was done about it. So Dan Applegate's work here, it ended up being important in the ensuing lawsuits. It was part of what ended up getting Corvair held responsible for the damages done. Because they didn't push this issue further, because there was this safety issue, they knew about the safety issue, and they didn't do anything about it. Now this is a case where whistleblowing didn't happen, but whistleblowing could have happened, right? So Dan Applegate could have done several things. So one thing he could have done, without going really outside, so going outside of his own organization, Corvair, Dan Applegate could have tried to reach out to someone in McDonnell Douglas. Right, McDonnell Douglas is who they're giving these parts to anyway. They're the people who need to know to make a decision about whether these parts should go on the plane. Maybe Corvair didn't want McDonnell Douglas to know because it put their contracts at risk, but maybe McDonnell Douglas needed to know anyway, and maybe Applegate had a responsibility to let someone at McDonnell Douglas know that these cargo doors were not safe. That would have been a kind of whistleblowing, right? That would have been a way of stepping outside of the normal organizational channels to let someone who's in a position to know do something about it. If Applegate had let McDonnell Douglas know, perhaps that would have threatened his job at Corvair, right? It might have made put his career at risk. And so he has to weigh the risk to his career against the risk to all the human lives in this defective door. But with that said, letting McDonnell Douglas know is not the end of it, right? So it's not a big public scandal. It's not letting the press know. It's also not letting any of the government regulators know. It's sort of the first step of whistleblowing. And you might think that Applegate had at least a responsibility to let McDonnell Douglas know if he actually thought that this was a safety risk, right? If he actually thought that there was a problem with the design, then he should have at least let the people who he was contracting this design out to know. And the fact that Dan Applegate didn't do this, sort of an immediately obvious step. There's a problem, right? So should Dan Applegate have whistleblowed, would you have been able to blow the whistle and go outside of these normal channels? Right, so Dan Applegate could have told McDonnell Douglas. He could have also told a government regulator, other kinds of regulation agency, to let them know that there's this safety risk. He might have been able to do it anonymously so that he wouldn't have faced any blowback himself. I mean, he could have also let the press know, right? Find a journalist who reports on these kinds of things, and have them publish it in a paper, right? Publish this stuff in a newspaper can bring a lot of attention to the issue, can bring government attention and also public attention. to get it fixed. So do you think Dan Applegate should have blown the whistle? That's another good question. Two more recent examples that you might know about, sort of less directly related to engineering ethics, or to engineering, but as good examples of whistleblowing related to sort of ethical standard. Chelsea Manning and Edward Snowden. Chelsea Manning was a Army analyst in 2010. She got access to a bunch of documents and videos about the war operations in Afghanistan, in Iraq. A lot of this information wasn't known. In particular, she released this video. It's on the Prezi. The video was of two journalists, credentialed Reuters reporters, who were killed by U.S. Black Hawk helicopters in Baghdad in 2005. At the time, the U.S. government refused to explain what happened to the reporters. And for several years, we just didn't know what happened. And then Chelsea Manning finds these videos and releases it to the public, so we know that, in fact, the U.S. killed these reporters and was lying about it and evading responsibility about it for several years. This wasn't the only information that Chelsea Manning released. She released a bunch of other information. She was convicted for violations of the Espionage Act. She was brought up on charges of aiding the enemy, but she was found not guilty of aiding the enemy. So Chelsea Manning gave all of her information to WikiLeaks in 2010, and WikiLeaks worked with a bunch of legitimate journalist organizations like New York Times and The Guardian and Der Spiegel. International investigative journalism outfits worked with WikiLeaks to go through this information, vet it for accuracy, edit it for any sensitive information that might put soldiers at risk. The standard procedures that journalists use when they're dealing with sensitive information like this. So Manning did not release this information to any enemy, didn't release this to any opponent of the United States, but released this to international journalists who were credentialed, responsible journalists able to handle this information. I made this slideshow back when she was still in prison, in a military prison, serving a 35-year sentence. And at the time, she was on a hunger strike. But just a few weeks before Obama's left office, Obama pardoned or commuted her sentence. So Chelsea Manning is set to go free in a couple of months. I gather maybe weeks. It takes some time to process all that stuff and to get her released. But it's much sooner. She's served as 7 years, something like that, of her sentence. Is getting out a lot earlier than she would have. This kind of release of information, right? This is public information, and Chelsea Manning made it very clear that she was releasing this information because she thought the public needed to know, that the public had a right to know what its military was doing in its name, and that the information being released deserved to be in the public discussion, right? For the sake of an informed democratic debate. Right? You might think of the contrast case here, which is how China deals with its information. If you are in China and do a Google, the equivalent of a Google search, the common search engine is Baidu. So in China, if you search on Baidu for Tiananmen Square, the results show you about Tiananmen Square, but don't have anything about the massacre except to say that it's a myth. But if you know the actual history, in 1989, there was a student protest in Tiananmen Square, this big public square, and students were protesting for several days, and then the Chinese government rolled in a bunch of tanks, slaughtered a bunch of people. Right? This is where the famous Tank Man video comes from. This is the actual video. I'm going to go ahead and play this, because this is maybe inspiration for whistleblowers. Right? This is the kind of thing that maybe inspires people like Manning and Snowden to stand up in opposition, right? So student protesters in Tiananmen Square, China rolls in the tanks, kills a bunch of people, pushes them out of the square, and Tank Man here with bags of groceries, plastic bags full of groceries, standing in front of the line of tanks, waving them away to go away. This is famous, very famous image. Oops. Probably seen the image before. You might not have seen the actual video where the tanks try to move around him. He's not going to get hurt in this video, although he does demonstrate an incredible amount of bravery. As far as I know, we don't know what happened to this man, though. He grabs he jumps on top of the tank. Oh, I love it so much. He's just telling him to go away. Knocking on the tank, go away, go away. He doesn't get hurt here, but I don't know that we know what happens to him. I don't know if we know who he is or what happens to him after this event. If I were to turn on the audio, you can hear gunfire in the background. Yeah. Guy pops out of the tank. Go away. Oh, I love that video. Right, the bravery to stand in front of that tank, to deliberately disobey orders when clearly your life is on the line, right? Clearly people are being killed for these same things, and yet to jump back in front of that tank as it rolls through. Pretty incredible stuff. Right, so if you search this stuff in the United States today, you get lots of information about what happened at the Tiananmen Square massacre. You get these videos and so on. In China, you don't get any of this information at all. In fact, internet users in China have tried to create other images to talk about the same thing because all of the actual images get censored. Right, everyone knows about the Chinese, the Great Firewall of China that censors all the internet traffic. But part of the point here is that the United States does the same thing, and we need people like Chelsea Manning to release this information so that people actually know what's going on. Edward Snowden did the same thing. Edward Snowden had a couple of movies released about him last year. He was an NSA contractor. He was just a contractor, but he wasn't a full NSA employee. He was just a contractor, but he was given enough security clearances that he could go in there and get access to thousands of classified documents, which he also released to WikiLeaks and other journalist outfits. These leaks gave lots of information, in particular about the domestic wiretapping program that the United States was spying on U.S. citizens without warrants, outside of the constitutional protections. We had hints that this program was going on, but we didn't know for sure until Edward Snowden released all this information publicly. Edward Snowden, Chelsea Manning released all this information and then turned herself in, and then faced trial and was in jail for a long time, and has now had her sentence commuted. Edward Snowden released all this information and then ran to Russia. He's now in Moscow, we believe. He's at in a embassy in Moscow with diplomatic immunity so that he's not getting taken out by the United States. The U.S. Military intelligence wants to bring Snowden back and put him on trial also for releasing all this information illegally. And Snowden isn't letting them do that. He's hiding out so he can't come home. Snowden, he gives interviews with the press sometimes at the embassy, but he can't leave the embassy or he might get get caught and brought back home and put on trial, and he's not willing to face trial. Chelsea Manning was willing to face trial, and she's getting her sentence commuted. I guess maybe it's relevant to go back and say Ernest Fitzgerald was also willing to face trial, right? He was willing to, under oath, tell the truth against his superior orders, and then face all the repercussions from that, right? And he had to challenge those repercussions in court for several years to see that justice was done. And maybe it still hasn't been done entirely yet. Our whistleblower protections still aren't very strong. Okay, with that said, let me go ahead and jump into the next part of the lesson, which is the debate between DeGeorge and Birch on whistleblowing. So I've already set it up a little bit, and I'll let you read the articles to get the details. But the real core of it is DeGeorge's 5 conditions on whistleblowing. So in the article, DeGeorge lists what he thinks are the 5 conditions on which it's okay to whistleblow or obligated to whistleblow. So there's 5 conditions. DeGeorge says the first 3 conditions make whistleblowing permissible. So this is when it's okay to whistleblow. And then DeGeorge, sorry, that's my cat in the background. So DeGeorge has the 3 conditions when whistleblowing is permissible, and then 2 more conditions when whistleblowing is obligatory, when it's an obligation to whistleblow. DeGeorge doesn't say that you should never whistleblow. He's giving these conditions to figure out when you ought to whistleblow. And the point here is that these conditions are fairly strict. They're fairly rigorous conditions to meet, which means that you're not going to meet them very often. More likely, you won't be in a situation where whistleblowing is obligatory under DeGeorge's conditions. And so the question here is whether these conditions are fair or whether we should have different conditions on whistleblowing. So let's go through the conditions. DeGeorge says that so the 5 conditions on whistleblowing. The first one is that there's a harm done by the product to the public, and that harm is serious and considerable. So it can't just be a minor harm. It needs to be a serious, considerable harm to the public by the product. Right, so it can't just be that someone's lying about something if it's not representing a serious and considerable public harm. You might, if we go back a little bit, remember the C5A that Ernest Fitzgerald whistleblows on. The harm here was $2 billion in cost overruns. It wasn't a harm that anyone was going to die. Right? There were no lives being threatened. There was a lot of money at stake, and that was taxpayer money. And Ernest Fitzgerald thought that taxpayers deserved to know that $2 billion of their money was being spent above what they had agreed on. $2 billion was being spent on this plane. Is $2 billion a serious, considerable harm? Is human life the minimum of harm that needs to be required? Or is it not just a human life, but is it a certain amount of human life? Right? Right? Where does this line get drawn? DeGeorge says some things about this in his article. I'm just sort of cluing you into some of the challenges of these conditions. So condition number 1, that the harm by the product to the public is serious and considerable. Condition 2, that you've made your concerns known to your superiors, and that condition 3 is that you've exhausted all available channels within the company, including the board of directors, and so on. Right, so remember, whistleblowing is stepping outside of the normal organizational channels to make some ethical issue known to someone who can do something about it. So the first condition here is that the harm has to be serious enough. And the second and third conditions is that you've exhausted the available channels within the corporation to let this grievance be known. The idea here is that you don't want to let the press know as soon as you've considered a problem. You want to at least make the channels available within the corporation for dealing with that problem. You want to at least try those channels because that'll be the first line of defense. Maybe because you signed the contract, your agency loyalty to the company requires that you at least make those channels known. Now, that can't always be the case, so remember, for instance, Edward Snowden. Edward Snowden was an NSA contractor. If Edward Snowden had made his concerns known to his superiors, all of his access would have been revoked and he would have been fired from the company, or worse, right? So Snowden couldn't have let this information be known to his superiors without sacrificing his ability to make the harm known in the first place. Right, so the question for Snowden was, is the harm serious enough to make it known to the public? And if it is, then maybe he needs to keep some of the secret from his superiors. Right? Maybe he can't go talk to the big bosses at the NSA, or else his plan doesn't go through. So these are the conditions just on when whistleblowing is permissible from DeGeorge. DeGeorge thinks that if you've exhausted available channels within the corporation and it's a serious enough and considerable harm, then you're allowed to whistleblow. That you're doing nothing wrong by whistleblowing, then it's permissible. But you don't have to whistleblow, right? This is DeGeorge's point, is that even if you meet all three of these conditions, you don't have to whistleblow. And if you did the Dan Applegate thing where you've made your concerns known to the company and then you stop there, DeGeorge thinks that that's all you're really obligated to do. That's where your obligations end, if these conditions are met. In order for whistleblowing to be obligatory, in order for whistleblowing to be something that you must do, ethically, that you have an ethical obligation to do, these two additional criteria must be met. So number 4, that you have documented evidence that would convince an impartial observer that you are right and the company is wrong. Right? That you can show, that you can prove, not just to a judge, but that you can prove to any impartial observer that you are right and the company is wrong. Right? That you have to have the proof, DeGeorge thinks. And finally, that the evidence is strong enough. Right? So not only do you have the proof that would convince someone, but that the evidence is strong enough so that going public actually prevents the harm. So it might be that you convince someone else, but they're like, yeah, but we can't do anything about it, and then nothing happens. And in that case, then DeGeorge says you don't have any obligation to make the public known. You have no obligation to blow the whistle. Let me do this one more time. DeGeorge thinks that if the first 3 conditions are met, then it's okay to blow the whistle, but you're not required to. DeGeorge thinks that you're only required to blow the whistle when you've met these additional 2 requirements, namely that you can prove to an impartial observer that you're right and the company's wrong, and that making this evidence public will prevent the harm from happening. DeGeorge thinks if you can't do these 2 additional things, then you don't have an obligation. DeGeorge's reasoning here is that, look, if you do go public with this information, and it turns out that nothing happens as a result, right? That it's not convincing, that the evidence you have isn't convincing to someone else, and that they're not going to do anything about it, then in some sense you've taken on a lot of risk by whistleblowing without any of it coming to fruition. And this is what DeGeorge means by saying that you're not required to be an ethical hero, that you don't have to put yourself in unnecessary risk in order to be a good engineer. Engineers don't have to put themselves at unnecessary risk. And if you don't have the evidence that would convince an impartial observer and that would change the harm, right, to prevent the harm, then you don't really have the strong obligation to make the harm known, and that if you don't make the harm known, you haven't done anything wrong. The point here is that DeGeorge has the criteria for whistleblowing set fairly high, especially for an obligation to whistleblow. On DeGeorge's view, engineers don't often have an obligation to whistleblow. On DeGeorge's view, it's often the case that whistleblowing requires more information, more documentation, more proof than the engineer usually has. And so if the engineer doesn't whistleblow, they're not doing anything wrong. They haven't violated any of their ethical obligations. So I have a quote here from DeGeorge. He says, given the facts of the case, what should we say about the Ford engineers? Where were they when all of this was going on, and what was their responsibility for the Pinto? The answer, I suggest, is that they were doing what they were supposed to be doing. They were where they were supposed to be, doing what they were supposed to be doing. They were performing tests, designing the Pinto, making reports. But have they no moral responsibility for the products they design? What, after all, is their moral responsibility of the engineer in a large corporation? And DeGeorge says, by way of reply, let me emphasize that no engineer can morally do what is immoral. Right? Engineers can't have done something that was immoral. If they were making an unsafe car that they knew was unsafe, then they have no. It's not moral for them. There's no ethical justification for them to release that unsafe product publicly. But then DeGeorge says, but in the Ford Pinto situation, no engineer was told to produce a gas tank that would explode and kill people. The engineers were not instructed to make an unsafe car. They were morally responsible for knowing the state of the car and for including that connected with placing and mounting the gas tanks. We can assume the Ford engineers were cognizant of the state of the art in producing the model they did. My reason for taking this view is that the engineer cannot be expected and cannot have responsibility to second-guess managerial decisions. He is not responsible for bringing the facts to the attention of the. He is responsible for bringing the facts to the attention, of those who need to make the decisions. But the input of the engineers is only one of many factors that go into making managerial decisions. Some engineers at Ford felt that the car could have been safer, but this is true of almost every automobile. Engineers at large firms have an ethical responsibility to do their jobs as best they can, to report their observations about safety and improvement to the safety of management, about safety and improvement of safety to management. But they do not have the obligation to insist that their perceptions or their standards be accepted. They're not paid to do that, they're not expected to do that, and they have no moral obligation to do that. Right. DeGeorge says explicitly that the engineer's job is to do their job as best they can. Right, that's their responsibility. Part of doing that job requires making their observations about safety known to management, but it's not their job to make management hold their own views. And managers, DeGeorge says, often make decisions on the basis of many factors, not merely engineering factors. And it's not the engineer's job to make sure that the managers only follow the engineers. They're not paid to do that, they're not expected to do that, and they have no moral obligation to do that. So says DeGeorge. So DeGeorge thinks that it's very rare that an engineer is going to have an obligation to actually go through with whistleblowing. Most of the time, they just have to follow the job, right? They just have to follow the script. If they followed the script, they've done their job, and that's the end of their obligations. On DeGeorge's view, someone like Dennis Gioia would have followed the script and would have had no further obligations to do more than that. Right? So if you thought that Dennis Gioia did his job and that's all that should be expected of him, then maybe you agree with DeGeorge also that engineers don't have a greater obligation to blow the whistle. But if you thought DeGeorge should have done more, and remember, Dennis Gioia himself thinks that he should have done more. Right? So if you think that Gioia should have done more beyond what he did to follow the script, then maybe you think that DeGeorge's argument here is wrong, that maybe, in fact, engineers do have an ethical obligation to go beyond what their job describes in the safety and in the interest of the safety and welfare of the public. And this is basically what Douglas-Birch argues. Right? Douglas-Birch argues that DeGeorge puts the standards for whistleblowing too high. In particular, these last two criteria. Douglas-Birch argues that a whistleblower might never be in a position to know for certain that it would convince an impartial observer, or that making the information known will prevent the harm. I mean, how is the engineer supposed to know that? First of all, the engineer's decisions here are often based on their own expert knowledge of the issue, and that expert knowledge might not convince an impartial observer because they might not have the required expertise. So the engineer might not actually know if the evidence they have is convincing enough. But Birch says it shouldn't be about whether you can convince someone, it has to be about whether you think the problem is serious enough to warrant the whistleblowing. So if the problem is serious enough, even if you're not certain that it'll convince anyone to take it seriously, even if you're not certain that it will prevent the harm, again, how will the engineer know? Right? The engineer might not be in a position to know. Right? Maybe if I give this information to the journalists, maybe no one reads that article and nothing ever happens of it. What Douglas-Birch wants to say is that even in that case, you might still have an obligation to whistleblow because you don't know ahead of time what impact it'll have. Or you have an obligation to try to have as big of an impact as you can, especially if you think the harm is serious. So if you think the harm is serious, Douglas-Birch wants to say that you have an obligation to make that serious harm known, possibly publicly, but to blow the whistle. And the standards here should be very low, just if you think that one, that there's a serious enough harm, and two, that the normal organizational channels aren't going to address the harm. Douglas-Birch says that that's enough to warrant the whistleblowing. Right? He notes that, well, what counts as good reasons? Reasonable people might disagree about what counts as good reasons, and there's no independent and general standard for this criteria. Conditions 4 and 5 are so demanding that they inject an unavoidable element of uncertainty into any evaluation of a complex case that could not be removed by further modifications of the conditions. Employees will almost never be obligated to blow a whistle on their employers in complicated cases. Instead of the conditions, instead of being conditions designed to determine whether the employee is ethically obligated or not, conditions 4 and 5 look more like requirements that prevent ethical obligation in almost all complex cases. Right? Birch worries that DeGeorge has set the standards too high, and that no one's ever going to be in a position to be obligated to whistleblow, and that sort of defeats the purpose of obligations to whistleblow. This is a complicated debate. These conditions are tricky, so think about these conditions, read the articles. They also appear in your quizzes. Write your essays. What do you think? Who should whistleblow? Should Dennis Joya have whistleblowed? Could you whistleblow if you're in the position to do so? What would your standards for whistleblowing be? These are the questions you should be asking yourself for this week's essay. One more thing from the book about whistleblowing, and then I'll talk about deontology. The book mentions some common sense procedures when you might think that you need to whistleblow. And the pages on the textbook are in Prezi. I believe this is on page. Yeah, it's on page 172 to 180. They go over the DC-10 and the C5A cases, and they go over some guidelines for how to deal with cases where you think you might need to whistleblow. These are not legal recommendations, and I should clarify that I'm not a lawyer. I'm not trying to give you legal advice. I don't have legal expertise. I'm a philosopher talking about ethics, talking about when your ethical obligations are for whistleblowing, and not your legal obligations. I encourage you to look up your legal obligations and think carefully about these things. Think carefully about the legal ramifications. Think carefully about the consequences in general of engaging in a whistleblowing procedure. And the book gives you some sort of straightforward recommendations when you're thinking about this. The first thing the book suggests, and this is also the first part of Douglas Birch's conditions, is always to try to work through your normal organizational channels. At least try. Maybe it's not going to be possible in some cases, like the Edward Snowden case, but you have at least an obligation to see what those channels are and to see to what extent you can use those channels to prevent the harm that you're considering. The rest of these conditions are really about navigating a corporate bureaucracy or any kind of institutional framework in the best way possible. Right? So be prompt in expressing your objections. When there's a problem, express them through those available channels as clearly and quickly as possible. Don't let these things fester outside of the normal channels, because the longer you take to have an official expression of it, the more ambiguity that arises, the more difficult it is to focus on exactly what the problem is. Be low-key and tactful. Be considerate of the feelings of others. Avoid personal criticisms that deflect attention from the issues. We've talked about this before with conflict resolution. When you frame a conflict in terms of the people involved, this is what raises people's defense mechanisms. This is what causes the conflicts to escalate. Right? Try to avoid personal criticisms. Try to keep the criticisms focused on the issues relevant to the conflict at stake, to the harm, the potential harm, or the normative issue at stake, the ethical issue at stake. As much as possible, keep your superiors informed of your actions. This has to do with working through the normal organizational channels, and to also make sure you know who's on your side and what resources you have in negotiating these situations. Sometimes your superiors can be an ally in these situations, and sometimes they can be a nemesis, and you need to know how that works. You need to know what parts of the institutional bureaucracy you can trust, what avenues you have for going outside of it. Be accurate in your claims. Keep formal records documenting events. Be accurate in your claims. Always tell the truth. This is part of the fundamental canons of the Code of Ethics. I'm not an engineer, and I've not worked in an engineering firm. I've been a teacher for a long time, and I know working with teachers, especially working with young students who are minors. I teach at a summer camp where it's a day camp. I mean, it's a summer camp where they stay in the dorms overnight. Having camps like that with minors creates all sorts of legal issues that the institution that I work for is very careful about. There's lots of lawyers involved. There's lots of procedures and rules for appropriate conduct and so on. In this environment, I know that that if there's ever a challenge, if there's ever anything that I sense as a conflict, the best way of dealing with it is to write a report. Even if I think it's not a big deal, if I write a report, then at least that conflict is documented, that I recognize there was a problem, and I put it through the official channels. So if anything develops from it later on, I have documented evidence that I was dealing with it early, right? If I don't submit that evidence early and something happens later on, and then they ask me for my report afterwards, there can be issues of hearsay. There can be other kinds of ambiguities that make the resolving the conflict more difficult, right? So always be accurate in claims, be prompt in your claims, document everything, keep a journal, right? If you're doing something that's a big deal and you want, and you think it might be an issue in court later on, keep a journal of everything that you do, everyone you talk to, what happens. Avoid isolation, consult colleagues. This is along the same lines as keeping superiors informed of your actions, to the extent that it's possible. Sometimes colleagues can be moles for the people that you are trying to whistleblow on, and that can make things difficult. Avoid isolation, partly to keep yourself connected to your community, to your colleagues. Some of those colleagues will also be assets and allies who will maybe even fight with you. But understand that your social network, your professional network, these things are what help carry you through a conflict like this. Consult professional ethics committees and consult a lawyer. If there's any legal challenges about anything, consult a legal professional who can talk to you about your rights, your obligations, your legal obligations in any case. All right, so that's the core of the lesson. I also have some things I want to say about deontology as the second ethical theory. Remember, we talked about consequentialism is the first ethical theory. Consequentialism is about weighing the consequences of our actions. Deontology, duty theory, duty is your secret word right there. Duty theory. Deontology is the second of these main ethical theories. Deontology, lots of people have talked about deontology in the past. It has a lot of sources that you might be familiar with. If you're familiar with the Christian tradition, the Ten Commandments is a kind of deontological. They're commandments, right? They're imperatives. They demand that you do some things. They don't tell you why to do those things, right? There's no explanation of the consequences that happen in those commandments. They just tell you what the obligations are. Thou shalt do this, thou shalt do that, right? Those are statements of duty, statements of obligation, statements of permission. The way the philosophers like to talk about this is that the deontologists put the right over the good. So the consequentialists prefer the good. Utilitarians, for instance, prefer maximizing utility, which is happiness. Right? And so the ethical theory is to maximize the good, maximize happiness, maximize utility. Deontologists don't want to maximize the good. They want to maximize the right. They want to maximize what the right thing to do is, even in cases where it goes against the good. Right? So I said this at the beginning of the lecture, but most particular cases, trolley cases, for instance, maybe the deontologists and the consequentialists agree with the same decision. They come to the same conclusions. The deontologists and the consequentialists don't disagree about their conclusions. Sometimes they do, but the point is not that they disagree about the conclusions. They often agree about their conclusions. The point of this difference is about the way that they justify their conclusions, right? The reasoning involved to coming to their conclusions. The deontologists don't think that the good should be maximized. They think that the right should be maximized, your obligations and duties. So I mentioned this at the beginning of the lecture, the right to bear arms. So, a deontologist might say that that codified right should be protected even when it causes a lot of people to die, right? So the proliferation of guns in the United States kills lots and lots and lots of people, kills more people than cars kill every year. And you might think that all those people dying means that maybe people shouldn't have guns, but the deontologist might argue instead that no, even if it kills a lot of people, the point is not how many people it kills. The worry is over the rule, over the obligation, the duty, and we have an obligation to protect people's right to bear arms. It's a Second Amendment, part of the Constitution, right? And this principle is more important than the consequences that arise. So even if it kills a lot of people, we should still hold the principle. Right? Even if people die as a result of the principle still matters more. Right? Remember, the consequentialists don't really have principles. Right? The consequentialist principle is to maximize the good, whatever it takes. If the consequentialist thinks that it takes lying, cheating, and stealing to maximize the good, right? If I lie to a bunch of people, that might make them, it might make them happier to lie to them. So this is, maybe I'm going to skip over Kant for a second. This is the example I give on Moodle, is the example of the noble lie. And the example I give is of Christmas sweaters. So my grandma, she knits these Christmas sweaters. Christmas sweaters are always hideously ugly. I never like wearing them. They're always uncomfortable and itchy. My grandma knits these sweaters by hand, and she spends a lot of time on them. And so when she gives me the sweaters, I lie and tell her that I like them. I tell her that I really enjoy them. Oh, how great! I really like the sweater. I love wearing it. These are all lies. I don't actually like wearing the sweater. I really don't want to wear the sweater. And as soon as my grandma goes home after the holidays are over, I stop wearing the sweater. But I tell my grandma that I like the sweater anyway because it makes her happy. If I told her that I hate the sweater, it would make her feel real bad. Right? The truth is that I hate the sweater. The truth is that I don't want to wear the sweater, and I wish you wouldn't make them because I hate them. But if I told her the truth, it would hurt her feelings. And so, right, the idea is that I tell her a lie. I tell her what's not the truth. I tell her that I like the sweater, and I tell her this in order to save her feelings so that she's not unhappy. I would be unhappy if she's unhappy. So I want to keep the peace. I want to keep people happy. So I tell her a lie. Right? The idea is that this lie is justified in this case by consequentialist reasoning. It's because I want the consequences to happen. Right? I don't want her upset with me. I don't want to start a fight. I want to keep everyone happy, and so I'm going to tell a lie. But some deontologists will say, no, look, lying is always wrong. And it doesn't matter if it causes better consequences. What matters is that you tell the truth. The principle at stake is truth-telling, and there's a moral failure when you lie, even when you lie to try to save someone's feelings, or even when you lie to try to keep the peace. It's better to lie and disrupt the peace, the deontologist thinks. I'm sorry, it's better to tell the truth and disrupt the peace, the deontologist thinks, than it is to lie and keep the peace. It's better to upset your grandmother's feelings and tell her the truth. I mean, because, look, the deontologist might argue, look, your grandma doesn't have all that much time left anyway, and filling the rest of her life with these lies, you're just encouraging her to waste the rest of her time on this thing that you don't even want anyway. Right? The sweaters are really a waste of her time. She's not giving you something that you like. If you tell her now, you might save her all that time. This is sort of consequentialist reasoning, but maybe you get the point. Right? The point is that there's a duty. There's a duty that you have to your grandmother to tell the truth. The proponent of this view is Immanuel Kant. Immanuel Kant was a 18th century thinker. 17th and 18th century. No, 18th century. 18th century thinker. 1700s, 18th century. Immanuel Kant argued that we have an obligation to tell the truth. And in general, his view is that, so this is a little bit complicated, his view is called categorical imperative. He's a deontologist, but he has this view. He calls it categorical imperative. Categorical imperative is a moral law. And Kant's basic general view is that you're not an exception to the moral law. Whatever the moral law is, what makes it the moral law is that it applies everywhere and always, Kant thinks. Whatever it is, he doesn't tell you what it is, but he says that whatever the moral law is, it has to apply to everyone. And you can't just make an exception because you want something different. You can't just make an exception simply because you would like something different. Right? You have an obligation to tell the truth. You would like your grandma not to be upset, and so you might want to lie to your grandma, but that doesn't mean you get to just because you want to. Kant says, look, you have an obligation to tell the truth. And that means even to your grandmother, even if it makes her unhappy. There's two ways that Kant says this, and I'll finish up pretty quickly, but there's two ways that Kant says this. He actually gives three different formulations, but I'm only going to talk about two. The first formulation here, he says, act only on those maxims that you can at the same time will to universal law. Act only according to those maxims that you can at the same time will to universal law. So a maxim, on Kant's view, is some principle of action, some reason why you're acting. And the categorical imperative says that only act on those reasons that everyone else can act on also. So for instance, lying to your grandma. I want to lie to my grandma. Actually, let me not use lying to my grandma. Let me use cheating on a test. So let's say I want to cheat on a test, and I want to cheat on a test because I didn't study, but I want to get a good grade. And the only way that I'm going to get a good grade is if I cheat. There's not enough time left to study, so the only way that I'm going to get a good grade is if I cheat. And I didn't study, so I want to cheat. So categorical imperative says, well, what happens if everyone acts according to the same reason? In other words, what happens if everyone cheats when they want to get a better grade? Well, so the point of testing is to evaluate how well people know the material. And if everyone cheats, then the test no longer serves the purpose of evaluating people's performance. Right? So in a world where everyone behaves in this way, where everyone cheats in their tests, there would be no point in test taking in the first place. People wouldn't give tests because they know that everyone's cheating. Right? The only reason that testing works is because most people don't cheat. Right? It's because most people don't cheat that I can take your test and actually evaluate your performance on the basis of that test. Right? So if you want to cheat, the only way that you can cheat is if everyone else doesn't cheat. Right? Because if everyone cheated, then we wouldn't have tests in the first place. So the only way that you're able to cheat at all is if everyone else doesn't cheat. In other words, if you're treating yourself as an exception to the law, no one else cheats except you. And that's what Kant says, that's what the categorical imperative says, is ruled out by the universal law. If there is a universal law, it applies always and everywhere, and you're not an exception to that rule. Right? So one of the things that thinking about the universal law in this way tells us, according to Kant, is that cheating is wrong, because if you cheated, the only way that you can cheat is by treating yourself as an exception, and you're not an exception to the law. Right, so Kant has a bunch of examples like this, where he sort of proves that you're not an exception to the law. The best analog that you probably know about that works the way that the categorical imperative works is the golden rule. You've probably heard this golden rule. Golden rule is a perfect deontological framework. It's a principle, right? It's a rule. It states an obligation. The golden rule says that you should treat others the way that you want to be treated. Right? Do unto others the way that you would have them do unto you. Right. So if you don't like being bullied, then you shouldn't bully other people. Right? This kind of thing. There's a problem with the golden rule, and this is a problem that Kant sort of recognizes. The problem with the golden rule is that sometimes people want strange things. Right? Sometimes the way that people want to be treated is not the way that other people want to be treated. My sisters really like glitter. They would love glitter all over everything. They would want nothing more than to have glitter covering themselves. Right? So if my sisters treated other people the way they wanted to be treated, then they would cover other people in glitter also. But most people don't want to be covered in glitter. Right? So you don't want a golden rule to apply to glitter because some people like glitter more than others, and other people don't like glitter. Right? So golden rule, treat people the way that they want to be treated. Like, this works unless the person wants to be treated weird, right? Wants to be treated in some strange way. Categorical imperative is supposed to solve this problem, right? Don't treat people the way that you want to be treated. Treat people the way that everyone should be treated. Right? Treat people the way that sort of the universal law treats everyone. Right? So don't make it specific to your particular interests. Make it the way that everyone should be treated. Right? Treat people the way that everyone should be treated. And one way, and this will become more relevant when we talk about artificial intelligence later on in the semester, but one of the things that Kant says as a formulation of the categorical imperative is to treat the humanity in others, to treat humanity, whether in your own person or in the person of any other, not merely as a means to an end, but always at the same time as an end in itself. A means to an end is something that you use for some other purpose. And Kant says, don't treat others as merely a means to an end, but also as an end in themselves. Treating something as an end in themselves is to recognize that they're also persons and they have their own end, right? So, for instance, when I get a taxi, I'm using the taxi to get me to the airport or whatever. The taxi is performing a service, is doing something for me. In some sense, I'm using the taxi as a tool. And you have to use people sometimes as tools in this way, right? People perform services for other people all the time. I use my taxi driver to get me to the airport. I use my doctor to keep me healthy. Right? In some sense, I'm using both these people. And what Kant doesn't say that you shouldn't use other people, but he says that you should when you use other people, always remember that they're an end in themselves and not merely a means to an end. So when you use so when I use the taxi driver to get me to the airport, also remember that taxi driver is a person, and in some sense, the taxi driver is using me for a fare, right? I'm the taxi driver's job, and I'm paying to keep that taxi driver employed. So I'm using the taxi driver in the same sense the taxi driver is using me, and it's because of our recognition of these shared ends that we can come together and cooperate and get both of these jobs done together. Right, and this requires not recognizing not only that they can serve some purpose for me, but that also I can serve some purpose for them, that they have purposes independent of my purposes, right, that they're ends in themselves. In other words, don't treat some people as objects, don't treat them merely as tools. People are more than just tools. This will become important because the question of artificial intelligence, and in particular how we should treat AI and robots, will run smack into this issue of treating them as objects. Because if it's okay to treat a robot as an object, then maybe it's okay to treat them without the same respect that we treat human beings. But this is a problem that will come up later. I'm just sort of laying the groundwork for this now. We talked about the noble lie. That's it for this lesson, lesson 5. If you have questions, come to the online hangout on Tuesday afternoon from 12 to 1:30. We can chat about some of this. And do the readings, get engaged on Moodle, and I'll see you next week. Bye.